Good evening, viewers, and welcome to the Personal Injury Law Show. This is a show that talks about everything to do with personal injuries, car accidents, work accidents, slips, falls, medical negligence. My name's Tony Carbone, personal injury lawyer of over 25 years' experience. With me tonight, I've got John Carancis, the accredited law specialist. Good evening, John.
Good evening, Tony. Good evening, viewers.
And also Steve. How are you, Steve?
Very well, thanks, Tony. Thanks
You're
for having me on.
an expert in work cover cases as well, aren't you?
I am, Tony, yes.
That's it.
Well, viewers, let's see what's in the news.
Well, John, what's in the news tonight? There's a few stories, but the first one is toothless dog laws bite councils. So this is a case where this gentleman here, Michael Ozumo, had got his dog back from the council because they confiscated the dog. They were going to put it down, but because the law is so complicated, Steve, he managed to get the dog back. What has to be done to make this simpler, to determine what dog breeds are dangerous and which ones aren't?
Tony, I don't think the council nor the state government know what the effect of these laws are. They're so complicated, they're so convoluted. The council officers, they're driving around the streets, they're trying to grab dogs, and then they're saying, no, we're not allowed to. What's going on here, Tony?
Well, it's got to be a restricted breed, Steve.
I think the laws need to be simplified, Tony.
Yeah, what happens is this. They've actually got it, someone's got to complain about the dog, then they reclassify it to a restricted breed.
So what, they're going to complain about my mini dachshund?
No, your mini dachshund couldn't hurt a fly, John, so...
Yeah, well, he's barking all the time. I mean, what is he a restricted breed now, Tony?
No, you can't reach kneecaps, don't worry about it. But look, the thing is that until you're a restricted breed and until it does something wrong, and then when it does something wrong, it's a bit too late, isn't it, Steve?
Oh, exactly right.
So, anyway, we need to simplify it.
Well, I guess it is a concern because in the end, these dogs could be put down.
Well, they do want to put them down, and quite frankly, John, it wasn't long ago that a bull mastiff, which is the same dog as this, attacked a young girl and severely mauled her.
And we've got the case in around August 2011 when the young girl died as a result of a dog attack. So,
exactly
it's shocking and something needs to be done and clarified, please.
That's it. The other story I want to go to is Qantas Jobs Cull. They're talking about 400 telemarine maintenance workers losing their jobs and about another 660 at Avalon Airport. This is part of our topic tonight of work cover, guys. And John, it's a real concern, isn't it?
It's a real concern. The manufacturing base in Victoria, it's declining, isn't it, Tony?
Oh, it is. It is.
And here we've got a massive employer, Qantas, literally putting everyone on notice that you're going to lose your job. We're going to make you redundant. Now, we've got a few concerns about that, Tony, haven't we?
Well, Steve, I mean, if you're acting for one of these workers that are trying to work, you'd almost give them advice to stay at home, I think.
I think you would, Tony, in these circumstances where there's such a massive cull of the workforce taking place. Yes, I mean, that is an issue that would be at the forefront of the advice you're giving.
It's a bit of a concern, isn't it, John? Because if they are working and then they get retrenched, they might not satisfy the economic test.
Exactly. My views very well, Tony. My view is, viewers, that if you're a worker and you're working with an injury at the moment and you're on notice that your job may be made redundant, you should be lodging a work cover claim sooner rather than later. You don't want to lodge that claim after you've been made redundant. You should see a work cover lawyer and lodge that claim prior to you being made redundant.
But John, I've got a bigger concern than that. Assuming you've got an accepted claim, Steve, and you're trying to do light work, and then the job's probably not right for you, but you're still sticking it out and you get retrenched. It could affect your capacity to get the certificate for loss of income, couldn't it?
Oh, it certainly could, Tony. If we pursue a common law claim, you need to prove the 40% loss of income or greater loss than 40%. Yes, it could certainly impact on your ability.
And the defendant in this case would argue that because you were working, you didn't stop working because of your injuries.
You've exhibited a capacity for work.
That's it.
In my view, the employer has set you up for you to fail your economic loss test. Under the legislation is strict, isn't it, Tony?
Oh, it is. It's very strict.
A worker in Victoria has to show that they have suffered 40% or more economic loss as a result of the work injury.
It's almost like a mathematical calculation that you're losing 40 cents in every dollar into the future.
And that has to be permanent.
That's exactly right.
Now, if you're working in a sheltered workshop that's provided by the employer, and you've basically been asked to sit in a room and copy out paperwork, which, Tony, that's what a worker recently advised me, that he's had a back fusion. He can barely walk at times. The employer wants him to come in and sit down in an office and copy out paperwork, actually by hand. And so he sits there for 4 or 5 hours a day. And you know what they do with that paperwork afterwards, Tony? They put it straight in the bin.
Jeez.
Now, they're setting him up to destroy his economic loss claim.
Which is the biggest part of most cases. Steve, let's go to the first case we want to look at tonight in the work cover segment of Filipovic and AG Staff Proprietary Limited. It's a Supreme Court decision of the Justice Curie. Can you give us the facts?
Yeah, it's a Court of Appeal decision, Tony. It involves a gentleman who sustained a right shoulder injury initially in, 2003. August 2003. He
was a fitter and turner?
He was a fitter and turner by trade. He worked for a number of other employers subsequent to that employment. He then suffered an aggravation of his right shoulder injury in employment in 2006 with a different employer. He lodged a serious injury application in respect of the shoulder injury against both employers, and the original County Court trial judge granted the worker a serious injury certificate against both employers for both heads of damage being general
by joining
damages.
the two injuries.
He considered the cumulative effects of the injuries, decided that both employments had materially contributed to the consequences of those injuries, and therefore granted a serious injury certificate against both employers.
Okay, John, the important thing in this case was that he worked for the first employer,
Yes.
damaged his shoulder, took some time off, went and got employment with the second employer,
Yes.
and aggravated the injury to the shoulder.
There's an aggravation.
And so the judge applied the principles in Gretsch, which we'll go to shortly,
Gretsch versus Orica, yes.
yes, and said a combination of the first and second gives you a serious injury against both employers. That was not the correct approach.
However, he also rejected the decision of Petkovsky and Galetti, Tony.
Yeah, that's the other case we'll be doing. So we're going to go to Gretsch and Petkovsky. So viewers, please stay tuned. Very important cases if you are interested in work cover. We go into a sponsors break. Thank you.